Welcome back to the Civic Forum. My name is Rory Truex. I'm an associate professor in the Department of Politics and School of Public and International Affairs at Princeton. I created the Civic Forum this past summer as a nonpartisan place and space for people to think about the bigger picture issues facing American democracy. Today, we're going to talk about the evolution of the court system and the role that the law is playing in democratic erosion under Donald Trump. We spoke this past summer with Kim Lane Shepley, and Kim made the astute point that today, when we observe these types of transitions, often when we think about authoritarianism, we think about tanks and soldiers and direct repression. And certainly there's some degree of that going on in the United States. But in general, when we observe these types of moments, increasingly they are done quietly and in the background and on paper. And so today we're going to talk with a friend of mine and a colleague of mine, Deborah Pearlstein. Deborah is the director of the Princeton Program in Law and Public Policy, and Charles and Marie Robertson, visiting professor of law and public affairs here at Princeton University. Deborah is one of our foremost experts on constitutional law, democracy, and national security, and she's currently writing a book, which is forthcoming in Princeton University Press, which is called Losing the Law. So thank you, Deborah, for joining us today.
Oh, thanks so much for having me, and also for creating this wonderful space, which I've become a fan of, listening to your past shows with political scientists and others. So thank you.
Well, thank you. And I should also say that I forgot to mention that this is not a official Princeton-sponsored podcast. This is an independent initiative. And so anything Deborah and I say today is not representative of our university. We are here as private citizens. So I asked Deborah to kind of give us the broad contours of the lay of the land with respect to the law and the courts under Donald Trump and how things have changed. That is an impossible task, and I've given her only 5 to 10 minutes to do it.
Okay, great. Well, framed that way, it is a totally impossible task. But what I thought I might do as a sort of a way into this conversation is to begin by responding to one of the things that I've heard a lot of political scientists say in this sort of particular moment. And that is that although, there were a lot of us in political science and law and others that saw the first Trump administration and said, wow, this looks like the beginnings of authoritarianism or a slide into autocracy, and we're quite worried. There's been a lot of surprise, including among, your previous guests who are among the world's wonderful, greatest experts in sort of how democracies die elsewhere around the world, who have expressed surprise about how quickly this seems to be happening now in the United States under Trump 2.0. How quickly this is sort of unraveling compared to the first Trump administration, and how quickly this is happening even compared to other countries like Hungary and Turkey and elsewhere, where we've seen what you folks call democratic backsliding. And I guess I think part of the answer to the question of why and how this now appears to be happening so quickly in the second Trump term has to do with how much of the rules or the norms that separate law from politics had already eroded by the time Trump came back to the White House at the beginning of 2025. So we've operated on this practical distinction between law and politics in the United States, and a lot of that had already broken down by the time he returned. So I guess let me just start out maybe by saying what I mean by the norms that separate law from politics, and how that works in a constitutional democracy. And we can talk about what folks mean by the rule of law, and all of these in greater detail if you like, but for now, maybe let me just give some examples, right? So what is the difference between law and politics, right? Law has what I'd call a norm of stability. This means law is past preferring. It likes the status quo. And this manifests itself, and I don't want to be mistaken by calling it a norm, this manifests itself both in hard laws, right, in rules, in case decisions, in the way courts behave, the way lawyers behave. But the norm of stability is just shot through law. So contract law, property law in the United States all have expectations of, we're going to try to protect reasonable reliance. If you've spent money on something, we're going to try to preserve the investment that you made based on the reasons that you made it. At the Supreme Court level in constitutional law, the norm of stability is manifested in ways like the principle of stare decisis, we're going to uphold the decision we already made unless there's some really good reason for doing otherwise. This is the opposite of what policymakers and politicians and legislators in Congress do, where they don't care at all whether their new law is the same as the past legislature, the same thing that the legislature passed. In fact, it's often exactly what they were elected to do, to change the way things are, right? Law is the opposite of that. This is one example of one of the normative differences. Another one is what I'll call the norm of legitimacy. Law, legal rules, courts, legal institutions, legal actors, operates as a reality-based enterprise. I like to think of it as, there's no lying in law rule. That doesn't mean lawyers never lie, far from it. But it does mean, and here a contrast is helpful too, right? So if you're running for political office and you go out on the campaign stump and you lie, in almost every circumstance, you not only are not punished for that by law, the Constitution, our First Amendment, gives you a constitutionally protected right to say exactly what you want, even if you are lying right out of your ears, or whatever the expression is.
That was very, that was a nice little, you made it very delicate there. There's different ways to say that, but you said lying out of your ears, so I like that.
My understanding is this is a family-friendly podcast, so
yes,
I'm going to try.
Right. That's good. Try not to swear. We try not to swear.
Thank you.
Yeah.
I'll do my very best. Sometimes it's hard. So lying in politics is fine. In fact, you lie on the floor of the House of Representatives. You are specifically privileged to do that under the Constitution. If you walk into a courtroom and take an oath and lie, you can be criminally prosecuted for perjury. That's just one example of how the law, maintains this norm of legitimacy. The rules are even stiffer for lawyers and judges, so we can be criminally prosecuted for all the same things that everybody else can be criminally prosecuted. But we can also be subject to sanctions of all kinds. Lawyering is a licensed profession, right? You can be fined, you can be suspended, you can be disbarred, you can lose your license to be a lawyer altogether. And then those are just sort of the formal sanctions you might be subject to. There are professional sanctions of all kinds, right? Most lawyers don't like other lawyers who lie. It tends to go badly for you professionally, career-wise, if you do that, right? So huge difference. Those are two of the examples of the norms that distinguish law and politics. So what do I mean when I say those had already been eroded substantially or destabilized substantially before Trump came back into office? So let me just take those two examples again. The norm of stability, and we'll use stare decisis because most folks pay attention to the Supreme Court, for better and worse. We have seen this just extraordinary period of rapid constitutional legal change over the last decade, right? Predating Trump. And you can think about this in different ways, and later we can talk about statistics and so forth. But, right, I just think about my constitutional law syllabus. I used to teach Common Law 101 when I was a law professor at a law school. And, it changes a little bit semester to semester. There are new cases all the time. You want to use contemporary examples and so forth. But fundamentally, the Common Law 101 class about how much power does the president have, how much power does Congress have, how much power do the courts have, was pretty stable, certainly throughout my lifetime. It has been 100% upended in the last 10 years. So landmark cases on executive power, on the power of the courts, rules of procedure, certainly rights that we usually don't even get to until Con Law 2, it has been rewritten. And one of the reasons why that has happened is the court has taken a completely different approach to stare decisis than it had before. It used to be, in fact, when John Roberts is confirmed as a justice in 2005, he testifies before Congress and says what everybody would have said then, which is that, well, you can't overturn a past case, just because you think it was wrongly decided, right? In the last decade, give or take, the Supreme Court has completely changed its view on that. And now in some of these major cases where we see landmark decisions being overturned, the court's reasoning for overturning right? The old rule is, well, that was really wrong. They just got it wrong, big time. Now, there's more to it than that, and we can talk about particular cases, but that's a dramatic change and has had sort of enormous consequences for how everybody interacts with the court and constitutional law. And for this administration, whether they expect what they do to be overturned, it now sees everything the Supreme Court has ever said about what the Constitution means as up for grabs. And it has some reason for seeing it that way. One last point about then the norm of legitimacy, which is, there's no lying in law rule or set of rules. So at the end, obviously, the last Trump administration, in 2020, there was this huge effort to effectively overturn the results of the elections. And lawyers played a central role in that effort inside the Trump administration and the president's private lawyers in part. And there were a lot of efforts to hold those lawyers to account after the fact. So Rudy Giuliani, for example, famously is disbarred by New York for basically lying about whether there was, not basically, for lying about whether there was evidence of fraud in the election. But the problem is those and other mechanisms that have really preserved a very vigorous norm of legitimacy among lawyers, including public lawyers and lawyers in the White House, have really been undermined by two huge changes. One is that the application of both formal rules of ethics and informal sort of professional accountability for ethics violations, especially for lawyers, have been undermined first by the development of what's called unitary executive theory, by a new understanding of executive power. And we can talk about where that came from and why it matters for legal ethics. And by basically what I call, in pieces I've written and in the book that's coming out, legal polarization. So we now have, separate partisan professional tracks through which lawyers, and especially elite lawyers, are trained and acculturated, especially acculturated. And these sort of separate tracks have had the effect of making it much easier for there being much less professional sanction attached, reputational sanction attached for lawyers who lie. In fact, we've seen kind of dramatic example after dramatic example, not in the last 5 years, but over the last 20 years, of very high profile lawyers who have violated ethics, who have ethical rules, who have lied, and then their careers have blossomed on these tracks. Trump 2.0, and I'll say this and then I'll shut up for now. Trump 2.0, and this gets back to the question about why so fast, has really capitalized on the destabilization of these norms, right? So in Hungary, for example, and I think Peru, you saw the government the ruling regime undertake to amend the Constitution, to go through this formal process through the legislature or otherwise. And it took a while, right? But it eventually happens. And in Orban's case in Hungary, to literally pass a law saying actually everything the Supreme Court has said for the last 20 years is no longer good law in effect. Trump didn't have to do that. A lot of that had already happened before he got back to office. Maybe most dramatically in Trump versus United States, the immunity case in 2024, which we can certainly talk about, but not only that. And it is far, far easier than it was, and continues to get easier, to find lawyers who will lie. He's managing to populate his administration with a lot of them because they no longer fear as much the risk of professional sanction. There is this pipeline now that helps ensure that, at least for lawyers who lie for partisan advantage, there might be a soft professional landing. So that they don't have to worry as much about the sanctions, either the formal sanctions or the informal sanctions that attach to lying before. So that's sort of, part of why I think this is happening fast. I think there's more to say, but I think let me stop talking now and let you ask questions.
Well, hearing you talk makes me wish we had 4 hours together, because and maybe we'll have to do another session in a few months or something like that. But I wanted to pull a few of the different threads that you put out there. The first is about the court itself and what you call legal polarization, and basically the politicization of the law. And we generally have a vague sense that the court has changed, the norms have changed, and in some sense it reflects the system itself, and that we've lost this moderate middle. We've lost moderate Republicans, kind of left-leaning liberal Republicans. We've lost conservative Democrats. And so the parties themselves seem to be pushing farther apart. We know polarization in society has increased. We know our media environment polarization has increased. So all of these things are happening at the same time. And it has permeated now the judicial system. You've been involved in the courts for a long time. You were a clerk at the Supreme Court level yourself. So can you tell us a little bit about just the Supreme Court and how that's evolved in the last few decades, and what it looks like now compared to what it looked like 30, 40, 50 years ago?
Yeah, so great. And I think let me do two things. I answer that question, but first back up to the beginning. You're set up talking about the difference between, or the relationship between, political polarization, right, which we all sort of generally know about, and what I call legal polarization, which is what I'm talking about here. So political polarization, right, just as you said, is this idea of this move to extremes among the parties. It's not that Americans didn't have differences before, but, especially on the right, and to an increasing extent even now on the left, the extremes are much larger and more powerful than they had been before. And there may be a lot of reasons for that. And that is certainly true. And that is not irrelevant to what I'm talking about. But what I'm talking about legal polarization, is a separation in the legal profession between lawyers and judges who still believe that they have to put the norms of the profession above the sort of desires of political or partisan loyalty, and the lawyers and judges who don't believe that anymore, right? And, those norms, which I talked about a minute ago, matter a lot. Now, that phenomenon is not a partisan phenomenon. So you can look at especially the lower courts and how they're reacting to the Trump administration. And you can find many, many examples of not only Republican appointed judges, but Trump appointed judges who are ruling against the administration, right? And they're ruling against the administration because they can read the law and they're applying ordinary tools of legal analysis and ordinary tools of factual assessment and evidence-based reasoning, and saying, gosh, you say there's a rebellion underway in Chicago and therefore you can call out the troops. Like there's no rebellion here. I have eyes and we have witnesses, and that's not what's happening. And you can see, in fact, a lot of Republican appointees, just like Democratic appointees, are ruling that way. But that said, right, so that's the difference in professional behavior. The reasons why we got there have a lot to do with the partisan break in the profession that has grown up over the last 40 years with the advent of the conservative legal movement. And that's the sort of separate professional tracks that I've been describing. And we can come back and talk about what the conservative legal movement is and how it works outside the courts, which I think is pretty important. But let me come back to the Supreme Court for a minute. And just give, a difference in, because this both goes to the difference in stare decisis and the difference in the court since when I was clerking in 1999, 2000, and where we are now. So Republicans, and Reagan, right, was elected on a platform of, among other things, there are now way too many procedural protections, way too many rights for criminal defendants. And it was at the sort of center of the conservative legal movement agenda and conservative agenda to get rid of rules like Miranda versus Arizona. You have the right to remain silent, right? A constitutional rule. And to be clear, right, Republican appointed justices have made up a majority of the Supreme Court since 1972. And by the time I'm clerking in 1999, we've had Reagan, we've had, right, 12 years, George H.W. Bush, 12 years worth of presidential appointments for even more conservative justices to the court. including the then Chief Justice, William Rehnquist, who was an extremely conservative guy, who had worked throughout his career to get rid of Miranda versus Arizona. And the court, the year I'm clerking, gets an opportunity to overturn the case. And the court ends up ruling 7-2 in an opinion written by Chief Justice Rehnquist that, yeah, well, if we were deciding that case today, I definitely wouldn't have given everybody a right to remain silent or required police to tell them that they have that right. But stare decisis means this law has been on the books for 35 years. We can't overturn it now, right? That's William Rehnquist, deeply conservative justice, in 2000, writing an opinion. If you look at the conservative justices on the court now, and this is almost everybody, but especially the sort of most recent four, so Amy Coney Barrett, Brett Kavanaugh, Neil Gorsuch, and increasingly, or especially Justice Alito, and even increasingly, oddly, John Roberts, that is not their view of stare decisis. And you can see that in famous opinions like Dobbs and elsewhere. I think there are other really important differences between how the court operates now and how it operated then. But I think that's one of the examples that I think is sort of pretty illustrative of some of the differences we're facing. It's not that control of the court has changed, it's that the kind of justices, the kinds of Republican justices who are now on the court view law differently from the way Republican justices on the court viewed it for up until, right, very recently, circa 2013.
Well, and one of the things you talk about in your book is actually just sort of partisan dynamics in the courts. And I'm correct the statistics if I mess them up, but it used to be the case that roughly 1% to 2% of cases at the Supreme Court level would fall on partisan lines. Now that number is, I think you said something in the territory of 20 to 25%. So it's not 100%. I think people misunderstand the court. Sometimes we think it's all partisan, and often they're just deciding pretty non-political issues, non-sensitive issues. But for the cases that matter, that are ideologically driven or motivated, that partisanship is coming out in full form in a way it didn't even 30 years ago. And when there were, as you alluded to, cases that could have been partisan, but were not. And so am I getting those statistics right? Is that the general story?
Yeah, that's roughly right. And you can see how this maps on. It happens roughly 2012, 2013 in the court. And so let me say a couple of things about that, right? First is the caution or the caveat that I always give to students and everybody else. Looking at what the Supreme Court does and trying to extrapolate from there what's going on with the law in the United States is incredibly dangerous and wrong in the sense that the court only decides this teeny tiny fraction of cases in the United States, and they get to pick exactly which ones they decide. So they get to set an agenda in ways no other court gets to set its own agenda. And, still half the court's docket is decided by, either 9-0 decisions or something close to that. So important to keep in mind. So having said all of that, and you rightly caveat the politically salient decisions, this is radically different. So when I was coming up, I clerked for two Republican appointed judges, one on the First Circuit and then Justice Stevens at the Supreme Court. That was not at all uncommon. My politics tend the other way, but that was not uncommon at all, right? Clerkships were not necessarily politically aligned in that way. And neither were justices, right? So if you think about sort of the major 20th century cases in which the court, makes dramatic new law or overturns previous law, Brown versus Board of Education, right, is written by, decided unanimously, written by a Republican appointed justice. This is the case, obviously, from 1954 that overturns the previous case from 1896 that had said, segregation in public train cars, racial segregation in public train cars is fine. The court in 1954 says for the first time the Constitution prohibits racial segregation in public schools. Dramatic shift in the law. They're overturning a prior case. But this is not a political. It's hard to spin this as a partisan political decision. The whole court is behind it, right? And you can give sort of comparable examples. Again, Roe versus Wade itself is authored by a Republican appointed justice in the first place. If you fast forward to a case like Dobbs, and this matters for a bunch of reasons, but including how the public perceives the court, if you fast forward to a case like Dobbs, which is the 2022 case that famously overturns Roe versus Wade, right? Again, the Rehnquist court had multiple opportunities to do exactly that, especially in 1992. It backs way off, says, stare decisis, we're not going to overturn Roe, right? So it takes another 30 years for that to happen, throughout which Republicans are in control of the court. Dobbs is a strict party line decision. You get all Republican appointed justices on one side of the court and all democratically appointed justices on another side of the court. This is not polarization in the sense of extremism, but it is a partisan split in how judges behave, at least Supreme Court justices behave, that is new in 20th century Supreme Court history, at least in the post-World War II era.
Well, and I apologize, I am not a lawyer, and so I imagine there might be a few lawyers listening who are just frustrated with the simplicity of my questions. But the implication of what you're saying is basically that given the change in legal norms, if a certain political party or the judges themselves want to get rid of a legal precedent, all they have to do is a case needs to bubble up to the top, bubble up to the Supreme Court that touches on that, and then they can do away with it as they please, right? So what you're kind of alluding to is the fact that all these precedents that lawyers, law students have to study really don't matter all that much in this politicized environment. Is that too extreme a statement, or is that kind of capture some of the truth?
Well, it's not too extreme a statement, but let me caveat it in a variety of ways. First, holy cow, could the Supreme Court just overturn previous precedent, even if they wanted to at any time? The answer to that question now is yes, if there are 5 votes. And the answer to that question before was also yes, if there are 5 votes, right? That has always been the case. What has changed is not the amount of power that the Supreme Court has. What has changed is how the people who we've appointed to the court perceive their role as justices. And that has a lot to do with the shifting norms. And now maybe like an okay time to come back to, or maybe I should come back now to the conservative legal movement and just sort of back up a little bit to explain an important part of how we got here, right? So Reagan comes into office. The conservative legal movement is born in the Yale Law School by a bunch of students in 1982. And the idea is at the political level, right? This quickly becomes not just a student sort of driven, I can't call it a political or social movement, right? It really is lawyers. They have powerful faculty advisors, including folks like Antonin Scalia, who's then a law professor who goes on to become a justice on the Supreme Court, Robert Bork, whose nomination famously fails, is one of the first faculty advisors. And Reagan is elected, and most of these people almost immediately go into the Reagan administration and become, for the next 12 years, the sort of leading lawyers in the country at the Department of Justice and otherwise. And the political impetus of the conservative legal movement is, look, the core political platform of the Republican Party circa 1980 is twofold. Number one, we've got to reduce government regulation of private business. And number two, we've got to sort of roll back the constitutionalization of these civil and social rights that we've seen, Roe versus Wade and many others. But despite Reagan having been elected by this large popular majority, certainly when he's reelected, Republicans realize they can't actually accomplish either of those two things by electoral politics alone. To roll back what they call the administrative state, right, agency regulation, they'd have to go through Congress, which created the agencies and passed the initial agency sort of empowerment to create regulatory rules. And And Congress, circa 1980, and for the sort of 50 years surrounding that era, has been in Democratic control. And people generally like agencies like the EPA and the Food and Drug Administration and so forth. And they're not going to be able to get a majority in Congress to just get rid of those agencies. What they need to do instead is expand executive power, expand the president's personal control over what the agencies do as opposed to Congress, right? So that's thing one they do. That's where unitary executive theory comes from. Thing two they do, and this gets closely back to the courts, is realize, well, we can't undo constitutional rules that the Supreme Court has announced through ordinary legislation. The way you usually do that, and people historically had done that, is constitutional amendment. But they didn't think, probably rightly, that they had sufficient majority or supermajority support to, for example, reverse Roe versus Wade through constitutional amendment. The only other way to do that is to get the Supreme Court to overturn 50, 80, 100 years worth of previous precedent. It's unheard of. It's unthinkable. How do you persuade people that that's an okay thing to do, right? How do you persuade lawyers who are trained in a principle of stability, in a norm of stability, that that's an okay thing to do, right? You needed a strategy that appealed both to elites and that could plausibly appeal to the public. And on the let's reverse a bunch of cases side, they developed this idea called originalism. And it was both a very serious theory of constitutional interpretation to some extent, although it was elaborated dramatically over the ensuing decades by scholars. But originalism also became this incredibly powerful Republican branded idea, which many conservatives in Congress, in the public, and even some conservative elites among lawyers viewed as coded as conservative outcomes in the courts. If justices say we're originalists, what they mean is we will vote for whatever the Republican Party wants. And that was the way they went about picking judges and picking justices to some extent, right? Outcome-based preferences. But when that really changes dramatically is when there is this break within the conservative legal movement, which hadn't really ever reconciled for itself the massive contradiction that originalism was created to deal with. Namely, we still think we're doing law. We still think there's a norm of stability. We still believe in stare decisis, but we want to overturn decades worth of Supreme Court cases. And what we've seen beginning in roughly 2013, when Roberts, right, one of these conservative justices, voted to affirm the Obamacare legislation, and even more when Gorsuch voted in 2020 to say that the Civil Rights Act extends to protect people to some extent who, on the basis of sexual orientation. There is a break in the conservative legal movement between those who said, no, we meant originalism as part of law, not originalism as something that would do away with stare decisis entirely. And the other faction, now ascendant, and now ascendant on the Supreme Court itself in the person of Brett Kavanaugh and Sam Alito and Amy Coney Barrett and so forth, that said, no, we meant originalism, and to the extent that's inconsistent with stare decisis, fine. In fact, we meant conservative outcomes on the court. And that's the sort of dramatic tension you see for the last decade or more in the conservative legal movement, but it is that faction that now controls the court.
Does that faction also map to sort of what we would call like an authoritarian versus pro-democracy faction? I mean, we're seeing this emerge in the Republican Party itself. There is this moderate middle of people, the never Trumpers, the Lincoln Project, people that are conservative ideologically, but view the way Trump is exercising power as fundamentally authoritarian. These are hugely important people in this particular moment because, one, it takes a lot of courage to do that. And defection, kind of elite defection from the Republican Party is important to provide a bulwark against authoritarians. There is, in fact, a publication called The Bulwark, which is very important and prominent. So does that that division you're outlining, is that map to this broader division of being kind of believing Trump is fundamentally dangerous and potentially even authoritarian? Is that also a fracture in the conservative legal movement, or is that just at the kind of political level?
Yeah, that's a great question. And I think the answer is not exactly no. And I'll give you a couple of examples of why I think that the mapping is not exactly right, right? So when I say there is this dramatic break in the conservative legal movement between, what I would call the sort of old school Federalist Society, traditional conservative legal movement folks, who I, with whom I would include folks like Justice Scalia, right? Who said on the question of, gosh, does originalism, if you believe in originalism, do you have to reject stare decisis? Scalia said repeatedly, famously, look, I'm an originalist, but I'm not a nut, right? In other words, that would completely upend the legal order that we have. And Scalia was not of that view, right? That's the kind of traditional view. The more radical view is something that emerges well before Trump. I mean, it exists at the beginning of the conservative legal movement, but it's a significant minority. But it begins to gain power within the movement, significant power, before Trump's election, right? So in 2013, John Roberts, flips his vote and ends up being the fifth vote to uphold Obamacare against conservative constitutional challenge. The Federalist Society National Convention that year boos one of the conservative justices who said, Roberts was right. It was rightly decided. This was a no-brainer of a case. And he is booed by this mammoth audience. When Gorsuch then upholds or extends the Civil Rights Act to protect discrimination on the basis of sexual orientation, or interprets the Civil Rights Act to apply, for reasons that fall kind of directly out of the text of that act and are totally unsurprising. Josh Hawley, now this is 2020, so Trump is around, but this isn't about Trump. Josh Hawley, senator, very conservative, but had been head of the Federalist Society at Yale when he was a student at law school there, goes to the floor of the Senate and makes this fiery speech that says, if this is textualism, if this is originalism, if this is what the conservative legal movement was fighting for, the conservative legal movement is now dead, right? What we meant, Hawley says, I'm not quoting verbatim, but you can pull up the text. It's really easy to find. What he makes very clear is what we meant by these things, what I meant by these things, what the sort of more radical faction of the movement meant by these things was the Republican outcome should win. And if that's not what originalism gets us all the time, and if that's not what textualism gets us all the time, then we will favor outcome over legal method or process.
Well, and the way you put that at the end is quite striking. And you've taught in law schools. You're not a law school anymore. I wonder what this does to kind of morale in the profession as a whole. I have a good friend who's roughly my age, someone I respect quite a lot, and I won't identify him, but somebody in the kind of do-gooder lawyer category, public service-oriented lawyer. And he said to me this past weekend, I don't know if I would go to law school anymore. And because if it's really about politics and outcome over the law itself, it's quite a shocking development and quite demoralizing. And so I want to pick up a little bit more on this before we turn to Trump. I want to carve out some time at the end of this to talk about what's happened in the last 6 months, 8 months. But this idea of legal polarization, and just to restate the thesis of your book, legal polarization is the growing divide in the profession between lawyers and judges who retain overriding commitments to the norms of stability, modesty, and legitimacy versus those who no longer do so. How is this affecting the pipeline of young lawyers and their socialization and how they're viewing their career paths? Can you tell us just a little bit more about what you're seeing as someone who's close to legal training?
Yeah. So that's hard, right? You can get 10 constitutional law professors in a room, and that would be a pretty sorry state of affairs, right? So we've all had to completely... I left law school and came to Princeton, which does not have a law school. So I still teach law, but I deliberately teach it to non-law students. It's easier, right? You can teach it as history, you can teach it as philosophy. There are a lot of ways to do it. You can teach it as an instrumental tool, which it still very much is. Constitutional law professors are expected to, and at a certain level have a duty to teach it as law. That has become enormously difficult, and different professors have taken different approaches. This is not a dilemma talking with other law school faculty that is limited to the left at all. I think everybody in law schools are struggling with this more in constitutional law than in other legal fields, certainly. But I have talked to many folks on the right, and there are many sort of the moderate, the relatively moderate, right? I would never have 20 years ago or even 10 years ago is called Antonin Scalia a moderate, but in this universe, he is absolutely a moderate. Those folks, of which there are still many, of whom there are still many in academia and out, and they're finding this increasingly unrecognizable as well, right? So demoralization, yes. Having said that, I want to go back again to the point I made about the sort of warping of the Supreme Court's ability to warp the constitutional space, right? One of the reasons that what we are seeing, and I want to be clear about, I've written about this before, of all of the institutions in the sort of Madisonian branches of government, right? The executive branch, Congress, the courts at this moment of real assaults on constitutional democracy, I think are by far and away the most effective branch at pushing back, at constraining some of the most lawless impulses of the current administration. And part of the reason of that, right? The administration is losing a staggering number of cases in the lower courts, both at the hands of Democratic appointed judges and Republican appointed judges. And that is a reflection of the profession as it was and should function. When the law is that clear, and when the interpretive questions are not complex, there is an enormous amount of agreement across parties that what we are doing in a courtroom is different from what we are doing if we were going into the voting booth to vote, or if we were going onto the floor of Congress to vote, right? And you see that reflected dramatically in courts across the country, right? So you can show this statistically, and Anna Bonica, who's a political scientist at Stanford, has done that. Steve Vladeck follows it as well. There's some disagreements about method there, but the bottom line is the one that I've given. The Supreme Court is literally the opposite of that. It's the opposite of that in outcomes, in terms of the frequency with which the administration wins, although we can talk about why that is exactly based on the kinds of cases that the court has taken so far. But it is also the opposite of that in the function that it performs. Cases usually don't get to the court unless the answer is unclear, right? Yeah. They are the unusual cases. They're the outlier cases. They're the cases in which there's disagreement below. So the entire institutional function of the Supreme Court is different than the institutional function of the way the law and the courts work everywhere else. And it would be a huge mistake for a generation of potentially law-bound students to sort of surrender the bathwater because of the baby. Does that one work? I'm not sure.
I've never fully mastered that one, but we'll go with it.
Yeah. Surrender the baby because there's still a lot of law going on. It's still an incredibly powerful check, more powerful right now than some of what we're seeing in the other branches.
When this chapter started, there was this feeling in the political science community about sources of democratic resilience in the United States. And one of the things people would point to was the courts. A while back, I wrote a piece about the legal profession and just actually how developed the legal profession is relative to other countries. We have among the highest lawyers per capita in the world. And often we think of, I drive on 95, I see like the ambulance chaser lawyer, sign after sign after sign going to Philly. But there's a range of lawyers, and not all of them are really helping democracy necessarily. But the fact that we have a well-developed court system and a well-developed legal profession is something to be grateful for, and comparable cases that are going through similar political processes don't. And so that would be what we pointed to at the beginning. And what you've just said is, I think, important to remember, which is that the dynamics you've outlined, the kind of legal polarization, the partisanship, they don't flow all the way through the system. It's not uniform, and it potentially is even concentrated in certain parts of the system. So it's important to remember that. We often would think about constitutional stability as another key feature in the United States. In Hungary, we observed basically they could amend the constitution at will and rewrote it to their liking. And one thing I've learned talking to you and Kim Lane Shepley and others is that, well, you don't necessarily need to amend the Constitution to change the Constitution or to kind of change the way the Constitution functions in society. And one of the things we've observed is what others have kind of called an aversion of the law, where we see these executive orders just come out with rapid pace that are in contradiction to statutory law. And the Trump administration is sort of just doing these things, putting out executive orders and creating legal ambiguity that then needs to be adjudicated in the courts, and that takes time. And so it's sort of this, it's like a shock and awe legal philosophy driven through executive orders. Can you tell us a little bit more about their thinking about the law and how those particular measures are being used in this first chapter of the second Trump administration?
Yeah. So I guess and when we say there, right, I think I've been thinking about the administration as several different fiefdoms, right? I really think there are different power centers. I think, Trump is not the legal strategist. Vote, to the extent there is one, it has very clear views. Then there's the Department of Justice, and there's still plenty of career lawyers there who are struggling to fit this into what a court might accept. So I guess I'll say two things by way of characterizing the approach, right? The first is to say, the first thing they did was, and I'm paraphrasing Shakespeare now, which is dangerous, is get rid of all the lawyers, right? So you had, at the end of the first Trump administration, when Trump demanded the Department of Justice just say there was electoral fraud, right? And make that claim, even though it was false, you had the entire leadership of the Department of Justice, including many of Trump's own appointees, right? Not just career folks, but political appointees as well, say, if you do that, we will walk out the door, we will resign. And Trump backs off that, right? And that's the bulwark, so to speak, against some of the reasons why his assault on the 2020 election failed. The first thing the administration does when they walk in the door is get rid of not only the senior career leadership in the Department of Justice, but entire offices in the Department of Justice. They pick, not for the most part, Federalist Society lawyers, but lawyers who are personally loyal to the president himself. And the willingness of those lawyers to make claims that are simply either without factual basis or manifestly illegal is a radical difference from the last Trump administration. So if you look at, for example, the executive orders that are coming out the door in the previous administration and every previous presidential administration in the modern era, they would have gone through checks by existing, usually career Justice Department, Office of Management and Budget, lawyers, staffers. That's not happening here, right? So what you see is the assault on the first level of the sort of first order legal defenses that have been so important in presidencies past. That's the first thing they did. The second thing, though, that I think we're seeing is a manifestation of this sort of radical view of the law that I was describing before. So Russell Vought, and he is not alone in this sort of radical conservative legal ecosystem in believing this way, has said and says we're in a post-constitutional moment, right? We are beyond law. We now control the Supreme Court. The Supreme Court is ours, and we should use that to the extent possible, whether existing law sort of matters or whatever existing law says. And they're doing that in a variety of ways, right? They're breaking the law first and asking questions later, right? They're litigating very strategically. So they're taking a lot of losses in the lower courts, many of which have proven effective, right? So you see money now flowing back to Harvard University because they won the court case, right? That in the district court in Massachusetts that they had not won before. You can see Abrego Garcia, right, brought back to the United States because you've had courts pushing back, and many other examples. The ones they're taking all the way up to the Supreme Court are cases that they think they know. Well, this is a court that is not going to worry if it needs to overturn, a 1935 precedent about whether the president can fire heads of independent agencies or not. The court, the conservative legal movement has long wanted to do this. We now have a majority that thinks stare decisis doesn't matter. And the administration is really capitalizing on those strengths to sort of proceed with its shoot first, ask questions later technique. That's a powerful technique. It's not necessarily a successful one in the long term. Quite the opposite, for two reasons. One is, as I said, they're taking a lot of losses in the lower courts. They're not getting a lot of what they want. And two is, when it comes down to it, right, these preliminary rulings in the Supreme Court about birthright citizenship and about some of these other things, the attacks on the law firms, if they actually get decided in the merits at the Supreme Court eventually, the administration is going to lose. But what's effective, I think, about the sort of blitzkrieg the legal blitzkrieg that they've been launching, is the optics, is the public impression that they are completely unbound by law and they are not interested, right? They are all powerful. And I view it as sort of part of my job as a law professor and otherwise to say, they're not. And they're going to win some, right? They're going to win some in the Supreme Court, big ones. But they're going to continue to lose a lot of them. And I think that's pretty important. It's a strategy that depends on fear working quickly and carrying them through the later stages when losses pile up.
Well, part of what we know about authoritarianism is that it's sort of a chill that takes hold, where people learn, and sometimes very quickly, that to oppose the regime, oppose the leader, brings real consequences. And then people are made examples of, and then that example has a chilling effect. So you don't need to repress everybody. You don't need to sue everybody. You just need to make some examples, and then firms, people fall in line, and they sometimes even obey in advance, which is the phrase people use. So when I look at all of these cases, I mean, the New York Times just got a defamation suit for $15 billion, something of that magnitude, which I don't know the economics of the New York Times, but I imagine $15 billion, if they were actually have to pay that amount, would be a bankrupting type event, something of that magnitude. And they are now going to have to litigate this. And just that fact that you have to get legal resources and go to bat for yourself is a huge cost in itself. And we think about Harvard and the New York Times are probably going to be okay because they're lawyered up. But when Trump starts targeting weaker actors or individual citizens with these types of lawsuits, some of them frivolous, that he will lose. But even the act of suing is important and sends that message, right?
Absolutely. And that's one of the things that I think has been, certainly in the first 6 months of the administration, because I think maybe things are starting to switch a little bit now, but we'll have to see. Certainly in the first 6 months of the administration, I think one of the things that was most disheartening was not what the administration was doing, all of which I think was completely predictable, but what the response was. So Trump has, throughout his career, and still again, filed meritless defamation suits against major media companies that are nuisance suits that may end up getting settlements of several $1 million or whatever, but they're not suits that would ultimately succeed if they were actually litigated to their conclusion. He does that again, and off the bat, you see massive companies like ABC, Disney, right, CBS settling these suits, these literally meritless suits. Those are, I think, what you would call obeying in advance, right? Similarly, the New York Times is one of the few that has said, fine, that in fact, the first time in the new administration, Trump sued the New York Times, that suit has already been thrown out, which is why he has to file a new suit. It's not going to be successful, but it requires a victim, the recipient of that sort of obvious legal overreach, to push back, at least to the extent of filing suit. And what we saw not only with the media companies, but with the universities and with many of the law firms was that they didn't even do that. They sort of struck at what they call striking a deal. Now it's indistinguishable from extortion, right? This isn't settlement where you have two parties of similar power who were sort of negotiating over a fixed point of law, right? Here, the universities, the media companies, the law firms had the law on their side hugely, and they didn't invoke it. Now, part of what we're seeing now is there were a few universities like Harvard. There were a few law firms like Perkins Coie, right? There were a few media companies like the New York Times who pushed back, and they are winning those cases, unsurprisingly, across the board, right? So 4 different law firms sued, saying the executive orders, you've issued against us are unconstitutional, a violation of the First Amendment, and a bunch of other things. They have, in front of 4 different judges, won their claims. If and when those cases actually make their way to the Supreme Court, which will require the administration to appeal an adverse judgment, right? It's in the administration's hands now. I think they'll lose in the Supreme Court as well. But it requires at least that. Mm-hmm. I would like to think we're now seeing more universities and maybe some others do that, but we'll see. I think the single biggest sort of most influential team or sector of society that is either off the playing field altogether or working in the opposite direction is big capital. So if you look at the law firms, for example, the ones that settled versus the ones that pushed back, the firms that pushed back mostly do litigation. They mostly sue people, right? And other companies. The firms that settled were the firms that do big mergers and acquisitions, transactional work, venture capital, private equity. And they're worried about, can we get our mergers approved through relevant government agencies? Can we continue to play ball? They're deal makers for a living. And they viewed it as inconsistent with their business models to fight that fight. Some clients, big paying clients, Microsoft among others, said, I don't want a law firm that's going to roll over. I want a law firm that will fight, and switched firms. If we saw more of that at scale, right, we might really see a behavioral change. Similar phenomenon, I think, are going on certainly in media companies as well. But that's one thing we haven't yet seen. I think the jury's out.
Well, and we're having a session in a few weeks with Daniela Balu-Ares, who is in business as one of the founders of Dahlberg, but has an organization that's about promoting pro-democracy norms in the business community, which I think is really important. But it's also, we know in political science that capital, business, whatever we want to call it, tends to be what we would call contingent Democrats. These are not a reliably pro-democracy force because they're worried about their bottom line. They are not interested in human rights. They're not interested in democracy. They're interested in profit. And so provided that profit goes in a pro-democracy direction, that's where they'll go. And if it doesn't, they'll go the other direction. And so I think it's important also to be realistic about what are the actors in our society that are going to put up some resistance. And I really appreciate your drawing the distinction between different types of law firms and how they reacted to the moment. So quickly, Deborah, we've covered a range of very sobering developments. One of the questions I do like to pose to people is, well, what are the paths out of this? Looking ahead 5-10 years, what are some changes you can envision that would help heal? How can the country heal? This is a chapter. We don't know how long the chapter will last. But what can the next chapter look like, and what are some potential reforms or new ideas that might help restore American democracy?
That's a great and really hard question. And I'm not a healer, right? So I'm more comfortable with the part of the question that is, what can we do to fix it, right? What kinds of reforms? And I guess I would say two things, right? One is, and both go sort of back to the points I was making earlier about, what got us into the place that we are and the fragility of the rule of law norms that we count on, which Trump has exploited and capitalized on and exacerbated, predate Trump. And so when we think about correctives and reforms, I think about, reforms that kind of correct that trajectory. One of the key things on that trajectory is this concept of executive power that has sort of become the monster that ate Sheboygan. I don't think the folks that developed unitary executive theory expected it to sweep as far as it did. I don't think they expected the court to say presidents have no liability for criminal activity in the Oval Office. But nonetheless, that's where we are. And I think the only way to change that effectively is not to do what we did before, which is tell the Supreme Court, reverse your previous decisions and thereby further weaken the norm of stability, but actually resurrect the process of constitutional amendment. I think it's doable. I'm actually optimistic about it if you view it as a 40-year project, and I think it's essential. The other kind of reform, and I'll speak about, law schools and the legal profession, but I think this is probably something that sweeps more broadly than this. In the legal profession, you have seen just this really dramatic partisan separation. And the Federalist Society is maybe one of the most famous on the right, but it's not limited to the Federalist Society. It begins in law school, through clerkships, through law firms, through public interest groups, and so forth. And that is incredibly destructive. You can't get rid of those organizations, nor do I think one should even remotely try. But I actually think the splitting of some of those power centers is a good trend. There are more voices, more diverse voices of all kinds, I think is essential to try to recover law as something that is even modestly independent of politics. That'll be part of my mission. We'll see how it goes.
Well, thank you for that. And my personal hope, and it's been a refrain of some of these sessions, is that this moment reveals some of the fundamental issues with our system. But in revealing them, it might create an appetite and a force for reform. And that might be constitutional reform. It might be legal, it'd be norms in our professions, whatever it is. But I think hopefully we emerge from this thinking bigger picture and perhaps more boldly about ways we might need to change in order to strengthen our democracy. So thank you to Deborah Pearlstein for coming and educating me on the law. This was so informative for me, and I hope it was informative for the listeners. Please be on the lookout for her book, which is going to be called Losing the Law, forthcoming from Princeton University Press, hopefully in 2026. And please tune in to future sessions. As I said, this is an independent podcast, so we have no advertising budget whatsoever, and I'm horrible at social media. So if you enjoyed this session, please do share it with friends and family, and I hope you tune in the future. Thank you, Deborah.
Thank you, Rory. Good to see you.